Very, very briefly, for those that don't know me, I was a transactional property solicitor for many, many years, and I became a mediator 14 years ago. And I do civil and commercial generally, but probably a bit more with property in it somewhere than anything else. But generally all sorts of disputes, apart from family and childcare. And I'm on the CMC board. And when I was invited to get involved in complaints, I hung my head and thought, "Oh no, this is the shortest of all the short straws. What can I possibly get out of or add to in relation to complaints?" But I'm pleased to say that the more I've got into it, the more I've found it's been a fascinating area to get involved in. I suppose, and other people might feel the same. It's a bit of a combination between seeing situations where you think they're but for the grace of God, and then there's other situations where you look at what mediators have done, and you think, what on earth were they doing? What were they thinking? They obviously weren't thinking. How did they possibly get into the situation that they have? And so I've distilled my thinking in the complaints area to be a combination of how can we avoid complaints. Obviously, the best form of complaint is one that's avoided because you have a proper procedure in place. But when it does happen, what do you do, and how is it best dealt with? Whether it's dealt with by the mediation provider, the mediation person themselves, or whether it's escalated to the CMC. So I'm going to give you a very quick run through of my thinking in this area. I'm going to invite obviously questions at the end, and people, I'm guessing, will also have their war stories. But the purpose of my talking is to try and get into the way in which we deal with complaints in the mediation world, because, like it or not, we're all in a complaint-ridden society where the complaints procedure that we deal with our energy supplier or our banks is set up so that, as far as possible, it's not emotional. It's not something that people should be frightened of. Well, of course, that's all very well in relation to a bank, but when it's a complaint that might be made against us or one of our colleagues, it's very scary, because we all hate being in a situation where we feel that we might have made a mistake. But then there are some mistakes that are much more obvious than others, and there are obviously people who are more vexatious than others in the way that they pursue their complaints. So I think that this should very much be an interactive process, and I'm going to run through the thoughts that I've got, but I would also welcome comments, welcome questions, because I think it's very much a two-way process. So to start at the very beginning, I think that a lot of what we do in order to avoid a complaint happening is common sense, and common sense can be expanded into a set of procedures by which we run our mediations, so that everything that we do in the mediation should be set out clearly beforehand in a note or in a procedure, so that the parties and the participants know exactly what to expect. Now, that might seem very obvious, but I think it also sadly has become obvious to me in looking at some of the complaints that have come through that many mediators just don't do that. It's quite astonishing. Some of the complaints that have arisen are because the participants just didn't know what to expect or what not to expect. So rule number one is make sure that you prepare thoroughly with a comprehensive note of what you do, what you don't do, what to expect, what not to expect. And you've then got that not only to fall back on, but to reinforce what is expected on the day of the mediation, and also in the preparation for the mediation. So that if the worst happens and a complaint is made, you can point clearly to this note and set of procedures that you followed. And of course, the more thorough you are in preparing, and the more thorough your written version of the preparation is, the less likely that there will be a complaint. So it might seem like stating the obvious, but the best way of avoiding a complaint is to make sure that everybody knows exactly what is going to happen, what's not going to happen. So I appreciate at the moment that there are so many different ways of preparing, and people and different mediation providers have their own systems, which is fine. I think that we're not yet ready for complete standardization. It's not a realistic prospect, but I think the more that we can establish a set of best practice, the better it will be for people coming into the profession. If all else fails and a complaint is made, we all have to have a published complaints procedure. That isn't to invite people to complain, obviously. It's to set out the way in which we would handle complaints if a complaint is made. Now, in order to become a CMC registered mediator, we have to comply with the EU Code of Conduct for Mediators, and the code sets out minimum standards which we all have to comply with. So that includes, for example, all complaints being acknowledged in writing within 5 working days of receipt, all complaints being investigated and responded to within 21 working days of receipt. And in the case of registered mediation providers, it states that the investigation will be carried out by someone other than the mediator that the complaint relates to. Seemingly absolutely obvious, but it needs to be said. The CMC website obviously contains full details if you wish to look at this separately. So I mentioned earlier about it being really important that the participants know what they've signed up to. I find that as well as providing a note setting that out, most people now that I'm aware of have some form of pre-mediation Zoom meeting or meeting in person where the procedure can be explained in more detail if required, or questions can be answered, because lots of people who come to mediation who aren't represented will not instinctively know how a mediation works, and what they're expected to do. So that's kind of, you'd think it would be glaringly obvious, but again, from some of the complaints that have come through, it's quite clear that people haven't had the procedure explained to them, and they don't, in some cases, don't appear to understand what the mediation actually involves. So an example that springs to mind here is a mediator who was also a solicitor, and he was a solicitor of 20 years standing, and he was being accused by one participant of sending a confidential note that he'd prepared for the mediator. He was being accused of sending it to the other side without authority. Now, you'd think this is so basic that it wouldn't be possible, but he had done it, and he had claimed that he'd done it with authority. And being a solicitor, you would think that perhaps he might have made a note, and he might have sent to the participant either a copy of the note or just a summary of what he was being authorized to pass over. But no, nothing there at all. And when he was confronted with this, he stuck to his position that he had made a phone call on a particular day, and in that phone call he'd been given authority to pass on this information. But lo and behold, he couldn't provide even a copy of a phone record to show that he'd made the call. So it looked pretty grim from the mediator's point of view, just based on the information that I've just explained to you. And the participant gave him a couple of opportunities to hold his hands up and say, look, I'm really sorry, I made a mistake. I shouldn't have done this. And in fact, when it boiled down to it, the complainant wasn't after compensation. He was only after an apology or an acknowledgement that the mediator had done the wrong thing. It took two efforts by the complainant. The independent investigator that we appointed to look into this did with permission from the mediator, did a Zoom interview, which was recorded with his permission. And eventually the mediator just caved in, and he said, I'm very, very sorry. I don't know what came over me, but I just did this, and I shouldn't have done. And but this whole process took at least 6 months, and so it was a long and difficult story, because obviously the time that was spent didn't actually need to have been spent if the mediator had held his hands up at the beginning. But he'd got himself into such a corner that he obviously felt he couldn't back down until the point where he obviously felt there was nowhere else for him to go. So there's so many morals of this particular story, but the ones that stand out for me are that firstly, he hadn't prepared properly at all. He hadn't explained the process. He'd made a fundamental error, but he was either too embarrassed or too felt that he put himself too much in a corner to admit of what he'd done. And he had tried for 6 months to defend the indefensible. So we're all human and we all make mistakes, and sometimes if we hold our hands up right at the beginning, they can go away, and they can be not as bad as they would be in this particular case, where it was escalated to a point where eventually the mediator just caved in. What we've learned also from this, from a CMC point of view, is that, quite apart from all the issues that I've already mentioned about preparation and informing people of what's involved, that the best way for us to deal with complaints, if they come up to the CMC level, is to set up an independent process. And we've now got independent investigators. We've got two independent professional people who run the complaints process with us, but externally. They report to us, and it's made a huge amount of difference. I also probably ought to mention that you need to see this in context, because thankfully currently we're only experiencing about 4 to 6 complaints a year. So you could say that's 4 to 6 complaints too many, but nevertheless, it's not a torrent, and hopefully it will continue at that level and ideally reduce. So
Roger, on that particular one, what reprimand or punishment was meted out, if any, to the mediator?
Okay, well, that's a good question. The punishment was that the mediator was suspended for 6 months. He was required to do a number of, I think it was 5 or 6 observations, and also some separate training. We felt that after examining this alongside the video interview that he had with the independent investigator, that actually we believe that he wasn't doing this fraudulently or with bad intent. It was just poor practice and a lapse of judgment. But hopefully in his case, he will have learned a horrible lesson, a really tough lesson.
And has he now been reinstated, or how long ago
no,
was
he's still in that 6-month period, actually. Yeah. So yeah, I think that example is quite an extreme example. The range of complaints that are lesser than that cover a whole host of different topics. But I think I picked out that one because it's got a lot of different aspects to it, and that fell into the category of, well, I can't believe that he did that. Not only I can't believe he did that, but I can't believe that he did that and then tried to cover it up because he was so embarrassed or ashamed. So we might look at that and say, hopefully it's not a case of there but for the grace of God, but you need you need to try and understand what some people do in situations when they feel they haven't got anywhere to go. Yeah, thank you. Thanks for the question. So another couple of examples to illustrate different points. In one case, an individual complained about some building works that had been carried out, and they complained that the mediator hadn't come with the tools to measure the works that had been done, and hadn't prepared a report on the works which had been carried out. Now, clearly, I think we would all say the same, that's why on earth did somebody complain about that when it's not within the scope of what the mediator would do. But this particular complainant, either they didn't understand that was not within the work that the mediator would do, or I suppose it's possible that they might have been vexatious, but it says to me that they hadn't had it explained to them, and therefore somehow they felt that it was something about which they could complain. Now, another case where...
Sorry to interrupt, Roger.
Yeah.
If that appointment came through the RICS, I say appointment in inverted commas, they now only accredit evaluative mediators. So if it had come through the RICS, that mediator would have been expected to come up with a recommendation, or at least evaluate the dispute.
That's interesting. So how...
And that's the only organisation that I know specifically only accredits evaluative mediators. Okay.
So how would that be covered in a standard note from the RICS as to the extent to which the mediator
would? Yes, I'm sure it would. Yes.
Okay. Because I mean, I've been involved in many boundary disputes, some of which I have co-mediated with a surveyor, and the surveyor would come along with their boundary kit and be in a position to measure up, but usually the surveyor would qualify the extent to which they're to be relied upon. I mean, that's that again is something for the pre-mediation prep, because it can be extremely useful in a boundary dispute where a surveyor comes along ready to measure, but he or she would still need to make clear the extent to which they're going to be relied upon. So we're getting into areas here which are more and more fraught with difficulty as to the extent to which we are or we're not responsible. Our mediation agreements will say that we're not advising and we're not giving an opinion, and therefore we're not to be party to any litigation. But if there is a specialist service that might be provided by, for example, a surveyor, then it needs to be carefully set out what they are or not doing. Another case involved a complainant who was upset that the mediator hadn't carefully read all of the bundle. Now, we're all familiar with receiving bundles of documents that often go into hundreds of pages, and some mediators believe that in order to keep an open mind for the day of the mediation, that they shouldn't read absolutely everything, whereas others will devour every word and make notes and understand absolutely every piece of information that's provided to them. And it's often a subtle issue of judgment as to how you come prepared with an open mind and how you come prepared having read absolutely everything that there is to read. It's a I suppose it's something that comes with more experience, and there are those that are much more experienced than I am, who might say, well, we only need to get a flavor of the dispute, and we can work it out on the day, because we want to hear what the parties themselves say rather than what the documents say. But I would never advise anyone not to read what's given to them. I think it's essential to get that sense and that flavor that you do read everything that's given to you, and you absorb it, and you then can read that in context with what you're told face to face. Conscious of time, so I'm skipping ahead.
Roger, just to say that there are a few comments and questions posted, but I think we'll take those at the end.
Okay.
If that's okay with you.
Yeah. Yeah, I think I'm going to sum up here with these thoughts, that the way that we are in our professional lives now and in our personal lives now, it's inevitable that there are complaints, and the key issue is how we deal with them. If we deal with them in an assertive and neutral way, it's much more likely that we are going to be able to diffuse the problem. I've often said in the past that most of the mediations that I've dealt with are about miscommunication, no communication, bad communication. So much of that also applies to complaints, because if you are assertive in dealing with the issue when it arises, you can often nip it in the bud. The situation that I described earlier about the mediator who shared the confidential information, if he'd held his hands up right at the beginning, then it would have gone away. So he only compounded it by dealing with it in the way that he did. And so most complaints can be dealt with by the complaints procedure that the individual or the mediation provider has in their own system. If that's not resolved in that way, then and it's escalated to the CMC, we believe that by dealing with it neutrally and now with independent help from professionals who are used to dealing with this in other professions, that's the best way of approaching it. And looking at the wider picture here, we're also looking ahead to the stage which is inevitably coming soon, where the Ministry of Justice makes mediation compulsory, certainly initially for cases up to £10,000. And we want to be in a position to be able to show the Ministry of Justice as a profession that we can self-regulate. And the last thing that we want is an MRA like an SRA, a Solicitors Regulation Authority, because that's not we don't believe that that's actually going to be helpful to us or the public. But watch this space. Any comments? Any questions? I haven't been following the questions.
No, I think, Roger, the best thing, I'll invite anybody who wants to make a comment or ask a question to raise their hands with the reaction box, please. David, you're first.
Thank you very much, Dave. I wanted to comment on the chat question: what happens when one receives the notes bundle just before mediation day? Well, maybe it's because I spent several decades as a practicing barrister, but receiving papers at the very last moment, i.e. the evening before the actual hearing, was commonplace. And the way to deal with it was you just got down and read the papers. And if it took till 1, 2, 3 o'clock in the morning, that is what you did. And that's what I've carried on doing when I became a mediator. I think if you've been supplied with papers, that is because the parties supplying them want you to have a look at them. So that's what I do. I have to say, when I ceased practicing as a barrister and became a mediator, I thought to myself, at long last, I will not be grappling with papers received at the very last moment. Some hopes. It just carried on like that as a mediator, as it did with the barrister. Okay, that's the point I wanted to make. Thanks.
Thanks, David.
I suppose I'd reply to that by saying that in most cases, you can encourage, persuade participants and their advisors to give you papers sufficiently in advance, but in some cases, however hard you try, it still comes to the last minute, and that's life. It's not perfect.
Oh yes, we do have time limits in our mediation agreements, but
yeah.
Graham, I think you're next.
You're on mute, Graham.
Yes, I was interested in the point about the mediator who hadn't, so to speak, performed the role of a quantity surveyor before starting the mediation. It just seems to me that it is potentially quite a difficult area. I mean, on the one hand, we do, to some extent, promote the idea of saying that a mediator ideally should know something about the area of law or expertise that is the subject matter of the mediation. And we routinely, of course, say, either in written statements to parties or at the beginning of a mediation, of course, I am not going to act as a judge. Of course, I'm not going to act as an advisor. But the list of things that you could go on to say that you're not going to do is infinitely long, isn't it? I mean, taking up Dave's point, yes, in some areas, it might really be expected of a mediator that they would have done some sort of homework. But generally, I think we feel that we're like a judge in this respect. We just deal with the evidence that the parties put to us. We don't go out to find it for ourselves. But I don't see an easy conceptual way to distinguish between what we should tell people that we do not do and what we should simply assume they know we're not going to do.
Well, I think we tell, in our mediation agreements and in our preliminary notes, we should explain what we do and what we don't do. The surveyor example is is a very good one as a specialist area, where if a surveyor is actually going to measure, set out calculations, then it needs to be very clear what he or she is or is not going to endorse as as a professional person, whether they're just doing it for guidance, for a separate third party to be appointed to confirm that. But that's all in the, I think it's all in the instruction, it's all in the brief, it's all in the note. There should be.
Hugh, I think you're next.
Thank you. And Roger, many thanks for that talk. Like you, I used to be a solicitor, and there was a time when I dealt with claims and complaints against the firm, which were mercifully few. I got our insurance brokers to come in and give a talk about risk management and claims generally. And one point that struck me was that these brokers, who were well known for insuring solicitors, said in almost every case where there was a successful claim made against a firm of solicitors, there had been a failure at the outset of the relationship with the client to set it up properly with a proper client care letter, or not sending the terms of business. And although the complaint wasn't related to the failure to send a proper client care letter, it seemed to be indicative of an attitude of mind towards the project that the solicitor in question hadn't really set everything up from the beginning. And I think that's just really to emphasize the point you made, Roger, about the importance of sending out the mediation agreement and explaining, what we will do and what we won't do.
Yeah, thanks, Hugh.
Alice, I think you're next.
Hi, Roger. Thanks for your talk. I'm not a solicitor. I'm not legally trained, but when I hear the comments about sort of like a judge, or assess the evidence or go through the evidence, it for me, it rings alarm bells in the sense that it's not our role as mediators to make a judgment call or to advise, because actually, when I'm CEDA trained, it's up to the parties to come up with a solution and for us to facilitate that. So my background is cognitive behavioral coaching, and I'm just interested in terms of the complaints that come across the table at CMC. Is there a notable difference between the complaints raised against legal and non-legal mediators? Does that give you any insight into how we work as different groups of people?
I haven't analysed the complaint input from that point of view, to be honest. I'd say from my perspective of the sorts of claims that have come in, to go back to the example that I gave about the solicitor who was a mediator, you would expect him to meet a higher standard in terms of the activity that he was conducting in understanding what confidentiality was at the very basic. So that was bewildering how he was able to do that at all. And whilst I wouldn't say it's forgivable if a non-lawyer does that, because we've been trained to understand what confidentiality is, I would have thought that that it wouldn't be possible for a solicitor to have done that, but
Well, I think it goes back to the judgment thing, in the sense that solicitors, because you've got the legal knowledge, probably think this is ridiculous. I know what this should be, how the results should happen, and I've seen it in the training that I've undergone, and I would say that's probably makes solicitors more vulnerable to that kind of thing.
Possibly. I mean, there's been, as long as I've been a mediator, there's been a debate in the profession about whether non-lawyers make better mediators, and there isn't an answer, but it's a great area for debate, because sometimes the lawyers get lost in the law and they're not looking at the situation commercially and sensibly enough, and maybe that was a feature of this guy's behavior, that he just got lost in he got lost in himself.
I've now got the next as Zoom user, whoever that might be. Anybody admit to being the Zoom user? In that case, I'll go on to Nick, please.
Sorry, let me unmute. Thank you. Thank you, Roger. That was interesting. Perhaps I still have my legal hat on at this stage, but I just wondered whether you or the CMC have seen any or experience of actual claims that have been pursued against mediators. And I also wondered whether you said that a solicitor, I think Alice, you said that the solicitor may be in a worse position when it comes to knowing about confidentiality and making a mistake. And I wondered whether his sort of ongoing denial was born out of a fear that perhaps the complaint was going to lead on to a PI claim or something like that. And I mean, obviously a mercifully small number of complaints. I wonder how often actually complaints go further, and maybe what happens in that situation. Does the investigation you've conducted, how does that then fit in with the a claim that goes forward? Is that evidence in the claim that goes forward? How does that all work? Maybe there hasn't been much experience of that, but I'd be interested to know.
Yeah, well, thanks, Nick. Going back to that particular case again, the deliberation that we had before the Zoom interview with the independent investigator, the deliberation was around whether or not he had been dishonest, and if we thought that he had, then we felt that we were obliged to notify the SRA, which would then have been a completely different situation for the mediator himself. We ultimately, with the investigator, came to the view that he hadn't been dishonest. He'd just been innocent but foolhardy, and therefore we didn't refer that onto the SRA. I'm not aware of any cases where we've actually had to, thankfully. So yeah, it's a tricky area, and I come back to what I said at the beginning, that preparation is the key, and that if everything is clear and transparent from the start, there's less likely to be cause for complaint, or that if there is a complaint, that it can be more quickly nipped in the bud.
Yeah.
Thanks, Roger. Carolyn, I think you're next.
Thank you. Thanks, Dave. Thanks, Roger. All good. Actually, less of a question and more picking up Lynn's point in the chat about your point, Roger, shame and cover up, and the predictable reality of feelings arising when we have negative feedback or worst case complaint. And it just prompted me to pull up a sheet of paper that I had some time ago on this topic, and apparently it's absolutely routine for any of us receiving unexpected feedback to have what is go through the pattern that's known as SARA, which stands for shock, anger, resistance, and acceptance. So just knowing that you or somebody you're dealing with is likely to go through that process can be very helpful. And I was given this sheet in anticipation of receiving 360 feedback on a big survey when last in partnership. And it was very helpful, actually, to understand that my response to some of the more challenging suggestions about how I might change what I was doing was entirely predictable and perfectly normal, and that I would come to a point of acceptance in the end. I just thought that was worth sharing.
Yeah, well, that's I haven't come across that acronym before, but that's really.
I'll send you more details, but the shock is sort of accompanied with, this can't be true.
Yeah.
It doesn't feel right, therefore it isn't. I don't like the message, so it can't be a good evaluation, or it can't be a sensible complainant, I suppose. Anger, because we've been attacked, and it's natural for us to want to defend ourselves. And the resistance element, you go through various stages of trying to rationalize it and intellectualizing it, or going through the motions and not really accepting it. But truth be told, there's probably a nugget of something in there that wants a change, however resistant we may be to that. And it may just need reframing.
Yeah, and it may.
So that we can hear it, and we know all about that.
Yeah, that's very, very true. And I suppose it may be that there's an L at the end as well, which is learning, because we've learned. I know I've learned so much from going through this process, and we never stop learning. We're all human. We all make mistakes, and it's how we deal with them.
Graham, according to the screen, your hand is still up. Do you want to say anything more? You're muted. You're on mute.
Yes, thanks very much. One of the things that interested me, Roger, was amongst the complaints that you get, mercifully small as they are, is it possible to establish categories of what are the most frequent?
Yes, it would be, for sure. I can't tell you off the top of my head what the individual categories would be. I'd say that the general category is that something hasn't been made clear at the beginning. So it goes back to the misunderstanding, miscommunication. If only that had been explained to me in the first place, then of course I wouldn't be complaining. Of course I'd understand.
Mm. I'm sure we all have long lists of things that we try to say in as summary a fashion as possible, because we don't want to bore people to death, and everybody wants to get on with it. But it's obviously important that some things should be there somewhere. or sent out in a list of.
Well, it should be sent out in a list beforehand. This is what I do. This is what I don't do. This is what I'd like you to do to prepare. And then at least it's all there. And you ask if there are any questions on it. You invite comments and responses to all the points that have been raised. But at least it's there.
Yes. Good. Thank you.
Thank you.
I still got Zoom user up. Is anybody owning up on it yet? No. Carolyn, do you want to come back in on something?
No, sorry, just hadn't taken the hand down. Apologies.
Okay. Here we have Zoom user. Do you want to unmute yourself?
Are you talking to Carl or to me?
To your good self.
Oh, okay. Hi. Just 3 or 4 very quick fire points. If you excuse the huge kind of ignorance, really, but so teaching my a grandmother, etc. But it was a really nice talk. Really enjoyed it, and it was very kind of masterly done, very diplomatically. I think that my personal opinion is that if people are going to pay at least £500 and they think they are giving you their documents, I think if you were to ask them, do you think I've read the documents? I think they would all expect someone to have had the courtesy to read the documents. I understand reasons why people might not, but that's just my opinion in how it might look to the lay observer. And in some cases, they pay a lot more than that. So that's just one point. The second one is the example. It is quite sad because obviously no one wants to judge anybody else, and people make mistakes and they learn from them. But we should be aware that where shame is where dishonesty is, and it's not where incompetence is. People can make mistakes because they make mistakes and they can be taught. But if you keep the fact that honesty is the best policy at the fore, that's the most important thing, I think, in any profession. And I understand that some people find that hard. I mean, there are surgeons who make mistakes, they kill themselves rather than admit it. I used to work for someone who actually used to say, never complain, never explain. And I just never, what's the other one? Never apologize. And he was a lovely man, but he ended up taking his own life. So I think people just keep a grip on just being honest, and then we can be supported. And then the third point I was going to make is that, do they waive privilege by coming to the complaints process, or is it just that only certain details are taken? And if that's the case, I'm not a statistician, I'm rubbish at statistics, but if it's just a sort of qualitative analysis, I can have a look through 10 or 15 and do a quick audit on what the subjects, what the subcategories are, and what sort of complaints are if you want. And that's it. That's my tuppence worth.
Thank you. Zoom user, thank you.
But it was a good talk. Thank you.
Carl, I know you've posted 2 or 3 comments. Do you want to repeat them or ask a question?
Oh yeah, morning. Can you hear me at all?
Yes, we can.
Yes. Sorry, I came in a bit late because I got another call on. So, but I'm going to listen to Roger's talk, and I think I heard some of it already at AGM. But I'm keen to listen to it because it's a really important topic. Just on a number of points, really, very briefly. There was an interesting comment made relating to change management. you know, this sort of defensiveness when a complaint is made, which ought not to be so amongst mediators or any professionals, really, because the whole issue of a complaint system and the freedom to do so, it's toward the improvements of the service. And when one is looking at, I think that one of the problems is that as a board member on a legal regulation and looking at complaints myself, and I know there's a massive defensiveness whenever a complaint is put in, but rather than an opportunity to see how one can improve. I think probably because it's called a complaint. So I was wondering whether or not we could find another word to express it and still do a complaint. That's one idea. Anyway, just one. I won't say any more because other people have got to have an input. Another word, can we put our heads together and think of another word which is more positive than the word complaint, a reframing of that word, but still effectively leads to that.
Carl, there's a danger that you'll have a complaint that you haven't got a complaints procedure.
Well, you could still have a procedure. This is the challenge, you see. Can we think of another word? I mean, for example, in America, in Harvard, they talk about compliance. I noticed the Harvard people are, you know, when we say, "Ooh, have you got a complaint system?" Harvard says, "Oh, you mean compliance?"
Okay, it was a slightly facetious comment on my part, so apologies.
No, it's okay. That's it anyway. Thanks, Roger, for your talk, which I will listen to later.
Very fair. Carl, it's a very fair point. I mean, we use a word that's got completely negative connotations, and that's used, you know, throughout the way that we live and work generally. It's unfortunate from that point of view, because it could be, you know, constructive criticism, it could be observations.
I'm getting feedback. If everybody could turn off their, oh, it's gone now. Thank you.
Mm-hmm.
Sorry, Roger.
Yeah, I'm just saying, you know, you could refer to constructive criticism or observations. It doesn't have the same weight, obviously, when someone genuinely has a complaint, as opposed to they just want to make an observation.
Roger, does the CMC issue any kind of guidance to send out to parties or their representatives beforehand that cover the various points that you've been making?
I was wondering if you'd ask that. I mean, it is a longer term project, because we have a complaints process and a procedure, but we don't have a centralized, this is best practice yet. You know, it's a work in progress.
Okay, thank you. It's gone the hour, so I'm just wondering if anybody else has still got any comments or questions they would like to say. If not, on everybody's behalf, thank you, Roger. Very interesting topic, and there, by the grace of whoever, as you say, we go. Everybody probably knows that these meetings are on the second or third Wednesday of alternate months, and the next meeting is booked for Wednesday, the 19th of July. I'll save the dates, but Wednesday, the 19th of July for the next one. If nobody else has got any comments, thanks again, Roger, and see everybody hopefully soon. Take care. If you want to stay on, If you want to stay on, and just have a chat, please feel to do so.